Welcome once again to Lehto's Law. Here's Steve Lehto.
An attorney named Craig tipped me off to a story. He said, Steve, did you see this cool case out of Illinois? And I said, no, I have not. And it's interesting because it's a big win for consumers. Specifically, it's a big win for RV buyers. But if you see what these people had to go through, you go, was that really a victory? And it was an expensive victory. And it's a crazy story. But this is the kind of thing that happens to people who buy RVs. So I've famously told people, don't buy an RV. Now, that was the title of a video I did. And I think I also wrote some articles entitled, Don't Buy an RV. But the real point I was trying to make was that the laws involving the purchase of RVs are not as good as the laws involving the purchase of automobiles. And so many people assume, oh, if I buy a $250,000 RV, it'll have lemon law protection and so on. And in most states, it won't. And manufacturers know this. So what they do is, if you have a defective RV and you bring it back, they'll say, oh, okay, we'll get to it when we get to it. But they won't be in a rush. So they're in a hurry to sell the RVs. They're not in a hurry to repair them. So this causes problems because many RVs are poorly built. And many RV dealerships focus more on selling than they do on servicing. And again, I'm preaching to the choir. People in the RV industry know what I'm talking about. People who've owned RVs know what I'm talking about. But what I'm talking about here specifically is someone who bought a defective RV and what they had to go through to get their money back. And it's not even that expensive of an RV, but it happened in Illinois. So I'm going to tell you the story. It's a case I'm reading to you that came down from the Illinois Supreme Court. And I could be mispronouncing the name, and I apologize. It's Asatura versus Vacation Land. And the plaintiffs, the people who bought the RV, their name is Asatura. I'm going to refer to them as the buyers, because it'll just be easier to understand. They bought something, they're the buyers. So the buyers purchased a recreational vehicle from defendant Vacation Land, Inc. Now, this opinion does not specifically spell out what kind of recreational vehicle it is, but I suspect it was the kind you pull. It was not self-propelled. And I've had people say, well, Steve, you keep talking about RVs. Obviously, trailers are different than No, they're all RVs. They're all RVs for legal purposes. You bought a big thing, okay? So we've talked before about widgets. Widget is the term they often use for just a nondescript item you purchase. And the point is that this is a widget. It is a non-automobile widget. So it's an RV. They bought it from a company called Vacation Land, and it leaked during a rainstorm. Now, they bought it in April of 2014. So that's clue number one. Something funny is going on here because this happened so long ago. And the trailer was a 2014 model year, and it cost $26,000. $26,000 is low end for an RV. You can easily spend six figures on an RV and more, okay? So they picked the RV up on April 25th. That June, they discovered water leaking into the RV from the emergency exit window. They brought the RV back to defendant for repair, and defendant then performed that repair without charge. That defendant in this case is the dealership. And that's important to understand. There's two different parties on the other side of this. There's the dealership and the manufacturer, okay? So in July of 2014, so this is still the same year they bought it, they took the RV to Michigan. During a rainstorm, the RV leaked extensively into the dinette area, damaging the walls and causing electric failures. Plaintiffs towed the RV back to defendant for repair on July 14th. Defendant was unable to repair the defect, so one of its employees told plaintiffs that they were going to send the RV back to the manufacturer. And that is an extremely common thing. I've had people tell me that they bought an RV, took it back to selling dealer. Selling dealer goes, look, we can't fix it. We just can't. We're going to have to send it back to the factory, or you can take it to the factory. I've had more clients than I can count who say, yeah, I took it to dealer, then the factory. Drove it down. There are some factories that actually have facilities where you can drive your RV down and stay in your RV until they get to it. So defendant's employees could not estimate how long the manufacturer would take to repair the RV. The buyers then called the manufacturer, and again, were told, we don't know how long it'll take. So on August 2nd, before the manufacturer had even come to pick up the RV, plaintiffs called defendant and verbally revoked acceptance of the RV. They said, we don't want it anymore. It's yours. It's not ours. We're giving it back to you. Revocation of acceptance, and we'll get to this in depth in a second, is the idea that if you bought something and it doesn't do what it's supposed to do, you can return it for a refund. revocation of acceptance. The manufacturer picked the RV up on August 4th and returned it around September 23rd. So they had it for more than a month, and as you'll note, they're returning it in September, and in the Illinois and Michigan area, September is past the end of camping season. So defendant called the buyers up on September 23rd to inform them that the RV was repaired and that they could come pick it up. So the buyer's attorney sent defendant a letter September 28th confirming the revocation of acceptance of the RV. So a lawyer sent them a letter, said, look, you don't know if you caught this. My clients told you they don't want it anymore. They're revoking their acceptance of it. So the fact that you repaired it, good for you. You just repaired your own RV. So the plaintiffs, the buyers, filed a complaint in the Circuit Court of Kane County seeking return of their purchase price and other damages under several theories of recovery, revocation of acceptance, which is a UCC claim, Uniform Commercial Code, and also the Magnuson-Moss Warranty Act. The Magnuson-Moss Warranty Act is often called the federal lemon law, and it basically says that anytime you buy a product with a consumer warranty, a consumer product that comes with a warranty from the manufacturer, that you can pursue it under state warranty law, and if you win, get your attorney fees and court costs paid. The UCC by itself does not generally allow that. So that's a huge, huge deal. So the whole thing really hinges on when they brought the vehicle back, they tried to repair it, wasn't repaired, they brought it back a second time, and when they were told, we don't know how long it'll take, when the buyer said, we don't want it anymore, was that an effective revocation, and was that legal? In other words, are they good with that, or can the manufacturer and the dealership go, no, it's still yours? So they went to circuit court where they filed their complaint, and the circuit court granted summary judgment to defendant on all 4 counts, finding that the record clearly showed that plaintiffs revoked acceptance but did not give defendant a reasonable time to cure. So they said, court said, if you revoke acceptance of this thing, you have to have done it after you've given them a chance to fix the problems. If they haven't had a reasonable opportunity to repair the defects, you can't revoke. So the question is, do they have to be given an opportunity to repair something that's defective? Now, you might say, Steve, this seems so obvious, don't they? Well, it's not so obvious, but I'll tell you that the trial court threw the case out and said, no, you didn't give them a chance to repair. That vehicle is still yours, the RV. So the appellate court also affirmed the case in 2018. So the lawsuit was filed 2014, and it went up to the Court of Appeals, and in 2018, the Court of Appeals said, no, again, you're stuck with this RV. You should have let him had more chances to repair the RV. So now it's in front of the Illinois Supreme Court, And in their analysis, they say, although plaintiffs alleged several counts, the only issue on appeal is whether plaintiffs could revoke acceptance of the RV under Illinois' adoption of the UCC. The statute at issue, adopted verbatim from the UCC, states, now this is almost identical language to what it is in all 50 states. So this is what it is in Michigan. The buyer may revoke his acceptance of a lot or commercial unit whose nonconformity substantially impairs its value to him if he has accepted it. And there's 2 different ways to accept that you could do this. If he's accepted it on the reasonable assumption that its nonconformity would be cured, and it has not been seasonably cured. But you'll notice it says, if he's accepted it on the reasonable assumption that its nonconformity would be cured. Well, the only way that could happen is if you knew it had a problem. And there's no allegation that the buyers here knew this thing had a problem. So that does not apply to them. It couldn't apply to them. So you look at what B is. And so it says there, the buyer may revoke his acceptance if he's accepted it without discovery of such nonconformity, if his acceptance was reasonably induced either by the difficulty of discovery before acceptance or the seller's assurances. So that applies. The RV leaked. There's no way to tell that by looking at it on a sunny day. So they walked around it. They didn't know it leaked. The seller didn't know it leaked. They accepted delivery of it. And then as soon as they discovered it leaked, they brought it back. They tried fixing it the one time. They brought it back the second time and were told, we don't know when we can fix it. So they revoked acceptance. So are they allowed to do that if they've accepted it without discovery of such nonconformity, if the acceptance was reasonably induced by the difficulty of discovery or the seller's assurances? So the Supreme Court goes through a lengthy analysis on this. By the way, that's UCC 2608 in most states. Some states renumber it. In Illinois, it's actually Illinois 5-/1-101 of 810, whatever that is. But UCC 2608. So 2 is a section of the UCC. 608 is a subsection, and that is on the revocation of acceptance. So on appeal to the Supreme Court, defendant does not dispute the defect without repair substantially impaired the RV's value to the plaintiffs. So they even go, look, all we're arguing about is we think we have a right to repair. Defendant relied on its argument that plaintiffs must have given it an opportunity to seasonably cure, which would have remedied the impairment of value. Remember, though, they actually gave him one repair attempt and then offered him a second one, and then apparently revoked when they were told, we don't know how long it's going to take. So defendant also does not dispute that plaintiffs were unaware of the defect in the RV at the time they accepted it. Therefore, 1A cannot apply. The section that says they accepted it on the assumption that it would be cured because they didn't know it needed cure. So they point out that interpretation of subsection 1B is an issue of first impression in Illinois. And this is funny because the UCC has been around a long time. And revocation of acceptance is one of the most well-known sections of the statute. And yet, the fact that it has not yet been ruled on by the Supreme Court of Illinois is not that unusual, because a lot of these cases get hashed out at lower levels and don't make it this high. And in fact, for a lemon law case or an RV case or some kind of other consumer case, to make it to a Supreme Court of a state is very unusual. So it's a strange one. But they point out that some states have ruled, some states have not. But Illinois can choose to do whatever it wants based on its own case law and its own interpretation. So the buyers argued that the statutory language is plain. The subsection that they're talking about contemplates a buyer who purchases an RV that they reasonably believe does not leak, but finds out later that it does leak. And the court wrote, we agree with this interpretation. The plain language of the statute evinces the General Assembly's intention to allow a buyer to revoke acceptance of a substantially impaired commercial unit under two separate and distinct circumstances. The first circumstance is when they know of the conformity, and the second is when the buyer accepts the non-conforming unit without knowledge of the non-conformity. Both situations contemplate a non-conformity that substantially impairs the unit's value to the buyer. Where they diverge is in the buyer's expectation. So one is a buyer who says, look, I'm buying it thinking you're going to fix it. The second is, I'm buying it, I don't think there's anything wrong with it. So then the question becomes, do they have the right to cure? Do they have the right to say, look, it doesn't conform, but we'll still fix it? So the fact that the buyers considered allowing defendant to cure does not obligate them to accept an unreasonable cure. Further, it does not obviate their right to revoke under subsection 2608. So because we find that the language of the statute is plain, we do not need to look at other states' interpretations. Even if we review those decisions, however, our research indicates that although a split of authority exists, a majority of them have interpreted their state's adoption with our decision today. And they cite a case out of Michigan that I'm very familiar with, Head versus Phillips Camper Sales, a 1999 case, which is a case that says a majority of courts considering this question have concluded that a seller has no right to cure after a buyer revokes his acceptance. So if you have the thing, it's defective, and you say, I don't want it anymore, it's defective, and you didn't know it's defective when you bought it, the Illinois Supreme Court just said they do not have the right to say, well, we can fix it and force you to take it back. If they offer to fix it and you decide to not revoke, that's a different matter. So notably, although it appears that the courts in some of our sister states would rule to the contrary, we did not find a case in which a court expressly interpreted the statutory language and found that subsection 1B required the buyer, give the seller an opportunity to cure. Rather, the decisions that run contrary to ours seem to base their decisions on policy grounds. So some states have actually said, well, it'd be good for business if we let these things smooth themselves out like that. But the court basically says most of these other arguments raised by the manufacturer and the dealer don't fly. So they wrote, we hold that the plain language of subsection 2608 of the Illinois Commercial Code does not require the buyer give the seller an opportunity to cure a substantial nonconformity before revoking acceptance. We reverse and remand for further proceedings consistent with this opinion. So this case will then get sent back down. And this ruling by the Illinois Supreme Court came down, I believe, in November, just a few months ago. So this case will then get sent back down to the trial court for trial. And the trial court may have a trial or the parties may settle. But here's the thing. This is a big win specifically for RV buyers. It is also a big win for consumers who buy products that don't work. But here's the problem. First of all, this is Illinois law. So other states don't have to follow this. This is in Illinois. But a lot of courts, when shown a well-written opinion like this, and say, look, there's no law in our state on this, but read this, Illinois, that will help you a long way towards proving your case as a consumer. But the real problem here, and this is the problem, is you'll recall at the beginning I said, well, you'll notice that they bought the RV back in 2014. 2014. And they got in front of the Court of Appeals after the case was thrown out by the trial judge a couple years later. And then they got in front of the Illinois Supreme Court in 2020. 6 years later. 6 years later. That entire time, the RV's been sitting probably at the dealership, and buyers haven't had an RV unless they went out and bought another one, but they also didn't get their money back for 6 years. So now if they go to trial, and let's assume they don't go to trial. Literally, they go to trial court, and the trial court says, what do you want to do? Well, we're going to settle. They settle the case. So they settle the case now. They're getting their money back 7 years later. And you'll ask and say, but Steve, couldn't they demand that they get their money back plus interest? Yeah, they can try to negotiate that. But the real point is that, let's back up. These people bought $27,000 RV, $26,000 RV. Okay? So they plunked down $26,000. And RV is unusable. They bring it back, go, we don't want it anymore. It's yours. We're revoking acceptance of it. Then they file the lawsuit. The lawsuit gets thrown out. There came a time when they were sitting in an attorney's office, and the attorney had to tell them, you guys, your case is thrown out of court. We can file an appeal. We think we're right. But the state of Illinois has never explicitly ruled on the point and the argument we're trying to make here. It's going to be a couple years just to get to the Court of Appeals. Do you want to go that route? Because you could, if you wanted to, go get the RV. They claim they fixed it. Go get the RV and either use it or sell it, trade it in, whatever. And the plaintiffs, to their credit, said, no, we want to proceed. We want to proceed. So they took it up to the Court of Appeals, and the Court of Appeals said, no, you lose. Threw the case out again. So they had to sit down again a couple years later in the attorney's office, and the attorney's got to tell the clients, guys, we lost to the trial court. We lost to the Court of Appeals. We could stop now. You could go get your thing, use it, sell it, trade it in, whatever you want to do. Or we could take a shot at the Illinois Supreme Court. Illinois Supreme Court, if they're like other state courts, don't have to hear cases just because they're filed. And the odds of them hearing our case are very, very slim. But we still think we're right. What do you think, guys? To their credit, the plaintiffs said, let's go to the Illinois Supreme Court. So they filed it up. Illinois Supreme Court accepted it for hearing. And they had hearings and briefs and all that stuff. And the Illinois Supreme Court comes down unanimously, 7-0, in favor of the plaintiffs, in favor of the consumers here, in favor of the consumers. So it's a big win, but it took them 7 years. And this actually explains why. So many people ask me, why is it that it took so long for one of these cases to be heard? And this is why. Because the defendants in this case, the dealerships, the manufacturers, those entities, those businesses in this world that are defending consumer claims, have the money and the inclination to go after and defend these cases. Because as you can imagine, if they lose this case on appeal, the dealerships and manufacturers are in a bad way. Because now they have to actually take better care of their customers. So if you are in Illinois and you just bought an expensive RV and it's got a massive problem that substantially impairs its value to you, you can revoke your acceptance of it and say, it's yours now, I want my money back. The problem, of course, is they still won't give you your money back until you sue them. And then, of course, you're going to sue them and go through this kind of rigmarole through the court system. Now, it'll be easier for people who come after these people because they can point to this as precedent and go, look, we've got an Illinois Supreme Court case that says we're right. They're still going to make you litigate. But something like this is actually going to move the needle in the correct direction for consumers. So as we go forward, you can bet that dealerships that sell RVs in Illinois are actually going to have to up their game a little bit, because if they don't, they're going to wind up getting a bunch of vehicles unaccepted, revoked back to them. And so it's a great case. It's a great case. It's Asatura versus Vacationland, Inc. It's 2019 out of Illinois. Case number 124285 out of the Illinois Supreme Court. And the attorney Craig sent it to me. Glad you did. Thank you very much. So it's a good case for consumers. It's a good case for RV buyers. I still don't recommend you buy one unless you really know what you're getting yourself into. So there you go. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Guilt, the gift that keeps on giving.